All rise. Oh yay, oh yay, oh yay. All those having business before this honorable court draw near and they shall be heard. The Honorable Judges McHaney, Sholar, and Vaughan, with Chief Justice McHaney presiding. God save the United States and this honorable court.
Gentlemen, please be seated. Case number talk is the state of Franklin versus Kilbourne, the United States, 25-140. Appellate, you may proceed.
Sorry. Chief Justice, Your Honors, and may it please the court. My name is Jacob Leonard. I am joined today by my co-counsel, Mr. J. Patrick King. We represent the petitioners in this matter. At this time, we would request 2 minutes for rebuttal.
Granted.
Thank you, Your Honor. Your Honor, my co-counsel today will be discussing the second issue at hand, and I will be discussing the first. And this is a case in which the state of Franklin has taken measured and reasonable steps to provide mental health care to its citizens within its borders. Your Honors, as I'm sure this court is aware, the state of Franklin is the largest state within the United States, as well as the most sparsely populated state. This makes delivering healthcare a uniquely challenging effort. After a 2011 fiscal crisis, Your Honors, the state of Franklin preserved a hospital-based mental health facility as well as a community-based care facility while consolidating underused programs.
Is the standard of review the same for both issues?
Yes, Your Honor, it would be de novo, as it is a question of law.
Is that agreed by both sides, or that's just your position?
That is my position on the first issue, Your Honor. As well,
Did the legislature cut funding for mental health, correct?
yes, Your Honor.
And it increased it by 5%, right?
Yes, Your Honor.
None of that increase was applied to mental health facilities, correct?
Your Honor, there's no indication in the record that either it has been put to use or it has not been put to use. There's no indication in the record of either instances. Your Honor, and it's based on these facts that the petitioners ask that this court reverses the 12th Circuit's decision and does not allow the respondents to bring an at-risk claim as for the following reasons. Because the 12th Circuit erred in recognizing at-risk claims by unduly relying on the DOJ's guidance document, as well as the second reason that the United States lacks authority to bring a Title II claim as government entities are excluded or omitted from the statutory text that is Title II.
Is there standing in this matter?
As it presently stands, Your Honor, no, the respondents would lack standing as they are not currently institutionalized, so therefore they are not in actual harm. This is all based off prospective harm, which is the idea that future harm could occur. Turning to the first point, Your Honors, that the statutory language of Title II itself is plain and unambiguous. As this court is well aware, I am very sure that in all statutory construct cases, the first thing that the court does is look at the text itself to determine whether or not there is a plain and unambiguous meaning as it goes in hand with the present dispute. As well, if it is determined that the language is unambiguous and plain in meaning, that's where the inquiry ends there, as it is coherent and consistent throughout the statute.
But aren't there two competing statutes? There's 42 USC and also the ADA. Is that what the other side's arguing, that there's?
The respondents argue that the integration mandate, which is Congress promulgated the Attorney General to issue provisions to interpret the ADA, the Title II of the ADA. They're arguing that the DOJ's guidance document should be given deference in order to determine what the text of the integration mandate says. However, Your Honor, that brings me into my first point. The Title II of the ADA provides impertinent that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of services, programs, or activities of a public entity or be subjected to discrimination by any such entity. As well as I previously mentioned, Congress instructed the Attorney General to issue regulations that implement this provision of Title II of the ADA. And one of these regulations is deemed the integration mandate. This mandate provides that a public entity shall administer services, programs, and activities in the most integrated setting appropriate to the needs of qualified individuals with disabilities. Now, Your Honor, nowhere within the statutory text of Title II of the ADA, nor the integration mandate do the words at-risk fear. This is citing back to the record at page 35, Your Honors, that as well as if a statute is to use such phrases as no qualified individual shall be excluded, or a public entity shall. And
Does this court decide who is at risk?
Your Honor, this court has long, this court should determine who's at risk by the level of the amount of. Your Honor, I'm sorry, one second. I'm trying to formulate my words into a sentence. The appropriate level of at-risk would be something in which the individual is going into the institution itself. It has to be brought while they are facing actual harm, not prospective harm, where the respondents are arguing that because there is the possibility that they could be going into mental-based care within the state of Franklin, again, that they are being discriminated against at the moment, or that they will be discriminated against. This is not inherent with what is talked about within Title II as it discusses actual acts of discrimination as well. Citing into case law in Olmstead, Your Honors, in Olmstead, Congress had determined that historically society tends to isolate and segregate individuals with disabilities. This is true. And they found that discrimination includes forms of outright exclusion and failure to make modifications to facilities. However, the court found in Olmstead that Title II is intended to provide comprehensive national mandates for the elimination of discrimination against individuals with disabilities, but it also simply holds that these individuals has to be unjustly institutionalized. At the present moment, the respondents simply are not institutionalized. They are within society, Your Honors. As well, going into the integration mandate, it requires that public entities administer services, programs, and activities to the most qualified setting, the most integrated setting. Whereas here, Your Honors, they are in the most integrated setting. They are within society itself. They are not within the confines of an institution or a community-based facility. They are within society. As well, Your Honor, going into some other case law, there is a 10th Circuit case, Fisher versus Oklahoma, in which this is the first case to actually recognize at-risk claims and determines that there is nothing within the statutory text that limits protections from discrimination to only people being institutionalized. However, this idea is completely backwards, as the 5th Circuit correctly states in United States versus Mississippi, Your Honors, that the ADA does not define discrimination in terms of prospective harm. This is going to be a recurring theme, prospective harm. The idea that future harm could occur, not that it will occur, just could occur. Your Honors, and although the court may be sympathetic to opening the idea that recognizing at-risk claims is okay, the court simply cannot enhance the scope of the statute just because it seems to be doing so. This is a legislative matter. Congress should have, if they intended to, included a provision or phrasing that says at-risk claims can be brought. Because they did not, the respondents lacked a valid claim, Your Honors. As well, that is exactly what the respondents are asking. The respondents are asking to read into language of Title II that is simply just not there. This goes back to the record at page 35, Your Honors, and as well, it's also not the petitioner's purpose to deny healthcare. The state of Franklin wants to help people and wants to take care of the people within its borders. It's just that these people are not in harm at the moment. They are not institutionalized. They are not in community facilities. They are simply in society to the best integrated manner. Your Honor, and turning into the second point, deference should not be given to the DOJ's guidance document. While it is true, Your Honors, that Loper Bright only applies to statutory text whenever it overturns Chevron, the petitioners will argue that our deference should be given and also rely on Kaiser v. Wilkie, a 2019 case decided in this court. However, Your Honors, Kaiser also says that our deference should only be given if there is a genuine ambiguity into regulatory text. As previously stated, Your Honors, there is nowhere within the regulatory text of the integration mandate that says at-risk claims can be brought. It does not recognize at-risk at all. In using the logic from Kaiser v. Wilkie, this court said that if there is any uncertainty, if there isn't any uncertainty to the meaning of a regulatory text, then there is no plausible reason to apply the our deference, and that the law gives an answer through that regulatory text. Here, Your Honors, the law does give an answer, and the answer is that at-risk claims are not included in the Title II of the ADA nor the integration mandate, and thus deference should not be given to the DOJ's guidance document. As well, Your Honor, Kaiser v. Wilkie quotes another quick case, a 2000 case also decided in this court, that Christensen versus Harrison County. And it says that if that is true, if there is no uncertainty, and if there is no plausible reason to give our deference, then to permit an agency's interpretation to be used as deferent or given deference would, under the guise of interpretation, allow said agency to create a new regulation in itself. And quoting again from Kaiser, even our itself does not and could not go that far into it. This just shows that using Kaiser and using our deference should not be given to this DOJ's guidance document, as there is no genuine ambiguity as to the statutory as to the regulatory text itself, Your Honors. Even more, if we apply Loper solely to the statutory text itself, there should be no guidance either. And that this court has emphasized that the interpretive function of this court is to determine what the best meaning is of a statute. And that this court must discern using its fullest tool belt to determine what the best meaning of a statute is. And Your Honors, this is concurrent with historic and constitutional notion that the duty of the judiciary is to determine what the current law is. And the current law is that at-risk claims are not valid and they are not recognized under Title II of the DOJ or Title II of the ADA and through the integration mandate itself. Your Honors, in sum, because of this failure of the statutory text, under Title II, respondents cannot lay a valid claim for at-risk claims, and this court should not recognize at-risk claims because there is nowhere within the statutory text that would allow for them to bring their claim, because at-risk is not being identified. As well, deference should not be given to the DOJ's guidance document, even under because Kaiser says that if there is no genuine ambiguity as to what the regulatory text is saying, then there is no plausible reason to give our deference to said regulatory document. And it's because of this, Your Honor, that the respondents request that, or the petitioners request that this court reverses the 12th Circuit's decision and does not allow the respondents to bring a claim because at-risk claims are not valid. Thank you for your time.
Good morning, Chief Justice, Your Honors, may it please the court. My name is J. Patrick King, and I'll be representing the petitioners on issue 2 in today's matter. That is the issue of whether the United States government can enforce Title II, and the answer is no, for 3 key reasons. The first of which is that Title II's plain text limits enforcement to persons. Then the ADA's structure differs from other civil rights laws that it is attached to that allow for federal enforcement. It is procedurally distinct. Then we look to the fact that allowing intervention would fundamentally alter the ADA's private enforcement scheme. Congress took reasonable and measured steps when this legislation was drafted. They knew they could grant unlimited enforcement authority, but chose not to. Now, this brings us to our first point. The plain text excludes the United States government. Now, when we look to 42 USC 12133, it states that remedies, procedures, and rights shall be the remedies, procedures, and rights this subchapter provides to any person alleging discrimination on the basis of disability.
If you're quoting paragraph section 32 or 33, the section right before 12132, Congress said the United States plays a central role in enforcing the standards established in this chapter on behalf of individuals. Doesn't that bring the United States in on this then?
It does have the ability to enact larger change within the system, but the private actions that are brought on Title II are reserved to individuals. So the enforcement and administration role would remain, but we would call that procedurally distinct from the individual claims.
Well, in the next section, 34, it gives the authority to establish, promulgate, administer, enforce to the Attorney General. How do you enforce if you can't bring an action?
Well, the United States would have the ability to continue to bring actions on its own as a separate, distinct entity. What we are doing is that these individual actions can only be brought by an individual. The key distinction is that under Title I and Title III, we have very specific language that the United States is brought in as an individual, but that is distinct in how it's written from Title II because of the addition of the word person and the addition of the word individual.
What is the correct standard of review in this matter?
Your Honor, we maintain that this position is de novo for both issues.
Why is that?
Well, because the second question is an issue of law. It is determining without deference to the lower court, which is the correct decision based on the law. It isn't a matter of discretion or factual questions. It's simply the law rendering it de novo. Now, rather than going through the typical lists for the definition of person, we aren't going to bother with Webster's dictionary or Black's Law Dictionary. These are purely persuasive pieces of material. When we looked at two cases, the first of which is Safe House versus Department of Justice, Third Circuit 2005, and Michigan versus Wayne County, that's the Sixth Circuit from the same year, they cite the Dictionary Act, which defines a person or alternatively whomever in this definition. It includes companies, associations, firms, partnerships, societies, as well as individuals. So this very commonly accepted definition that is used and applied to this section does not recognize the United States government as a person or individual. Then going further into the issue of the phrase individual. Now, throughout this legislation, it does vacillate back and forth between person and individual. Potentially, there could be some questions about the government as an individual, but the citation of the Dictionary Act shows those words are interchangeable, which would render that argument moot. Next, we need to look at the fact that Congress's choice must be respected. In Connecticut National Bank v. Germain, the court finds that we must presume a legislature says in a statute what it means. Congress had the ability to create express federal authority for the United States to intervene. The authority we question is not the United States' ability to act. It is the ability to intervene on a matter of disability under Title II. Congress could have very easily put that in. It could have matched Title I and Title II, but it does not. So because of that, when we apply the plain meaning rule to this, we find that a plain text reading of this law simply does not allow for the United States to be a person or an individual for that matter. It was a clear and measured step to demonstrate that the members of Congress had the intent for Title II to be applied this way. Next, we need to look at the fact that the Americans with Disabilities Act differs from other civil rights laws. The first key point on that is that Title VI does not include a person limitation. So this would mean that it is distinct from Title I and Title III, Why would it be drafted in a different manner than the others if it were merely meant to piecemeal have some other enforcement remedy added from the outside? It simply would not make sense with congressional intent, and it would render it procedurally distinct from Titles 1 and 3.
Is there any guidance in the legislative history regarding the writing of Title II versus Title I and 3?
The legislative history on this, there is a degree of it. And recalling it, it states, I believe it uses the word advised. I'm not certain on the exact verb, Your Honor. I'm going to rely on the tense of the verb to indicate considered, thought of in the past tense. So I cannot say for this court's interpretation whether that's here or there, but it's merely that it was considered to some degree. Then we need to look to the Fifth Circuit that my co-counsel addressed earlier. Now, the Fifth Circuit emphasized strict textual interpretations of the ADA requirements. As he stated earlier, these were distinct because the individuals were currently in a facility. But the legal approach to it, the strict reading, is why this circuit is the one this court should examine. The 11th Circuit also offers in Chief Judge Newsom's dissent, which is merely persuasive, but offered for the sake of argument, in which he states that the ADA contemplates enforcement by individual persons rather than the United States. The detailed analysis supports the plain meaning. Now, he states contemplates, thought about, could have, but there's no action that would state this could move forward. The belief is that it was considered, but chosen not to move forward. Then there's the issue of Haymarket DuPage LLC, the Village of Itasca. It's the Northern District of Illinois this year. This found that the United States cannot enforce Title II based on person limitations. And mind you, once again, this is merely persuasive, but we have seen that dissents, we have seen verdicts from circuit courts that have shown and demonstrated under similar facts that the plain text reading is the trend among the courts. We would ask this court to continue that, continue upon their arguments to make that the standard. Next, we have to look at the fact that intervention fundamentally alters enforcement schemes. Schemes that exist to protect individuals where the United States acts on its own. And then I would also like to pose to this court that numerous alternative remedies exist for both individuals and populations outside Title II if they were to face discrimination. First, we need to examine that fundamentally for intervention, we have to go back to the Federal Rule of Civil Procedure 24A2. The section states that they must have an interest relating to the subject matter. Now we can look at an interest as essentially a unit of value of something, a reason the outcome would matter to that organization. Now, the United States has a broad goal of protection. Their interest is the population of the United States. An individual litigant is a separate entity. They are a citizen of the United States. They are not all. And their individual remedies are those that can solve problems with individual litigation on their part.
What if they settle?
If they were to settle, they would have that option. But if the United States were to intervene, they would not have that opportunity.
Page 5 of the records, the lower court's memorandum of opinion and order, they talk about the fact that the United States provides the funding. If you're providing the funding, I mean, your state, Franklin, went from 3 facilities to 1 facility. They went where the petitioners or the plaintiffs have to drive 2.5 to 4 hours. Faced with that scenario, why doesn't the United States, as the providing the funding, have the responsibility to ensure that their regulations and statutes and rules are followed by stepping in on behalf of the individuals here?
Well, the United States has several different options in this matter. The first of which is the United States holds the purse strings on that funding. If Congress or another body were to place restrictions on that funding to open more facilities, they would have that enforcement authority and the ability to make that happen more quickly, more effectively, and with more weight. So this would be more efficient to the individual person.
You think holding hearings and committee hearings and votes and all that would be more efficient than what the United States has done in this choice of stepping in as an intervener?
It would be nice to say our Congress was expedient. I do not believe that to be the case. But in this scenario, it also balances out the tremendous costs of having the United States brought into every such matter. This would become an issue of overload for the courts, where if you had several individual cases with the United States intervening, I believe if we were to bring in this matter today, it would be 26 plus additional months of additional litigation and over 273,000 in additional costs to the defendants. So if the United States were to intervene every time, the cost would quickly outweigh other options. It would simply be a massive increase on local dockets to have the United States have the ability to intervene in every individual matter.
You're quoting figures from the dissent at the lower court, I believe, page 33 of the record. But that's the first case. Obviously, the first case is going to be more expensive, but as this continues, if we set a precedent here, if this is allowed to continue, it's not going to cost as much in the future because they've already been through all the background required. Isn't there some values to getting this out of the way first?
Well, Your Honor, I would say that there is not, because it does open the floodgates after. As this court makes precedent for what lower courts can follow, we should consider cases that will follow this one based on stare decisis. And if we create that situation where those additional costs build up, even if there's a cost reduction in this case, where it's lowered for each additional plaintiff, imagine that by 1,000 nationally. Does that lowered cost continue to compound? Most likely not. With a limited amount of resources, the court system would essentially be overwhelmed by that. But there is a valid alternative that individuals who potentially do not have the resources to bring an individual suit may have.
It almost sounds like Franklin is saying we don't want to fight the government with all the risk. We'd rather fight little people who can't defend themselves.
I believe the state of Franklin holds that, I believe the individuals of the state of Franklin in our matter are essentially the little people that we are also representing too. They will have the tax burden of a lot of this. They will essentially be footing the bill. So we are not punching down towards the little people. We are simply considering all the people who will be involved with this massive change in infrastructure. Your Honors, it appears I'm running a little close on time. Today, we would ask you to find that the United States government cannot enforce Title II of the Americans with Disabilities Act. First and foremost, because the plain text excludes these arguments. Next, because the ADA differs from other civil rights laws, inconsistent with procedure. Then finally, intervention would fundamentally alter enforcement schemes and make it more difficult for both the courts and for individuals to recover and have their interests truly represented. We ask you to respect Congress's intent and to respect their reasonable and measured steps to ensure this is enforced correctly. Because of this, we ask you to overturn the 12th Circuit's decision and find in our favor that we can take the necessary, reasonable, and measured steps to follow the law.
Chief Justice, may it please the court. My name is Darian Morgan, and my co-counsel Danielle Watkins represent the respondents in this matter. Discrimination against those with mental disabilities is often marked by neglect and indifference, enabled by a system designed to push them out of their communities and into institutions. This case is not just about the historical mistreatment of those with mental disabilities. This is about providing them services to uphold their autonomy and dignity. This court should affirm the Court of Appeals decision for two reasons. First, a person at risk of future institutionalization may maintain a claim under Title II of the ADA. And second, the United States does have an interest in this matter and may file a lawsuit to enforce Title II of the ADA, which my co-counsel will be addressing. Title II of the ADA extends to those at risk of future institutionalization for three reasons. First, the plain meaning of the integration mandate is ambiguous and requires further interpretation. Second, the R standard rather than the Loper standard is controlling in this case. And third, the guidance documents issued by the Department of Justice are owed deference. Respondents would first like to assert that the standard of review of this issue will be de novo. The plain meaning of the integration mandate is undeniably ambiguous here, and further interpretation is needed to understand its proper meaning. The first step in statutory interpretation cases is to determine if the language at issue is plain and unambiguous in regard to this view in the case. There can be no thought of deference to the guidance documents without the proper review. For a regulation to be ambiguous, it must be susceptible to multiple reasonable meanings, and the agency's interpretation must align with one of those meanings. The proper interpretation here requires a public entity to provide services, programs, and activities, whether the person is institutionalized or not. This directly aligns with the agency's interpretation of the integration mandate. Respondents would like to make clear that this is what an overwhelming majority of circuit court cases have interpreted this to mean, including the 2nd, the 4th, 6th, 7th, 9th, and 10th circuits, as seen on page 29 of the record. Respondents ask that this court join the majority of those courts that correctly asserted that a cause of action may be brought under Title II of the ADA for those that are at risk of future institutionalization. Petitioners argue, however, that the interpretation only applies to those that are currently institutionalized, relying on one lone case out of the Fifth Circuit. Most pertinent here is the evidence-based support used for the government to bring a claim in the United States versus Mississippi case. A study of outside experts was performed, covering only 154 people out of 4,000 those who had been admitted to state hospitals within a minuscule 2-year period. This is based on mere generalizations, Your Honors. The government argued that the entire mental health system of the state of Mississippi violated the integration mandate on a generalized survey.
Is there standing in this matter?
Your Honor, we are not currently addressing the standing issue. However, our respondents would argue that there is standing in this case. Under Title II of the ADA, Congress has explicitly empowered the Department of Justice and its staff, including the Assistant Attorney General, to both enact and interpret their own regulations. And their interpretation is that it clearly provides to those that are at risk of future institutionalization. And so thus respondents do have standing in this matter.
How is at risk determined? By what standards is that measured?
Your Honor, the at risk would be determined by medical professionals that are deeming those individuals to be at risk of future institutionalization, and those services would need to be provided for them in this issue. The risk here in the United States versus Mississippi was based on the system deficiency. It did not tie it to any individuals. Respondents are not challenging that the state of Franklin's entire mental health system violates this mandate based on a generalized population survey to bring this claim. The present case is tied to 3 named individuals. We are not bringing this claim based on what-if hypothetical scenarios. The integration mandate is susceptible to multiple meanings and thus is ambiguous and requires further interpretation. Respondents would also like to address a public policy concern here, that Congress has addressed their findings that discrimination against those with disabilities is a socially pervasive issue. The Olmstead decision provided an exception to the integration mandate, where a state may demonstrate that it has a comprehensive, effective working plan for placing qualified individuals in less restrictive settings. And even with the 5% increase in the budget, as seen on the record on page 16, there is no evidence that the state used these resources towards community-based care, much less even provided a working plan to help in an attempt to help these individuals. The state here had a way out, and they chose not to even address a plan to help these individuals, Your Honors. Respondents would next like to address the ORA standard and why it is controlling in this case and why it allows this court to owe proper deference to the guidance documents. The ORA versus Robbins standard is proper here because the integration mandates language is a creature of the Department of Justice's own regulation, and their interpretation provided in the guidance document is controlling unless plainly erroneous or inconsistent with the regulation. Conversely, petitioners claim that the Loper-Bright standard overrules the ORA standard, which is erroneous. Loper-Bright is not applicable to this case in fact or law. The Loper standard incorrectly reasons that the courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority without any judicial deference to the agency's interpretation. However, respondents would like to make clear that in the Loper case, the Department of Labor was attempting to interpret an ambiguous federal statute passed by Congress rather than their own regulation. At issue here is the interpretation of an ambiguous regulation that was enacted by the Department of Justice, who has provided their own interpretation of their own regulation. As provided on page 20 of the record, it is clear that the agencies, it was their interpretation of their own regulation.
First, those regulations or circulars allowed by virtue of authority in statute.
Your Honor, could you clarify that question, Your Honor? Could you clarify that question, Your Honor? I want to make sure that I'm answering
The
it.
agency is allowed to create guidance documents that the ability for them to do that is based on this authority in the statute.
Yes, Your Honor, you're absolutely correct that Congress has empowered them explicitly to enact regulations and to, through the Assistant Attorney General, to be able to interpret these regulations, Your Honor.
Why should Loper?
The Loper standard here is addressing a federal statute that was passed by Congress here. We are interpreting a regulation. We are interpreting the correct interpretation of the integration mandate in this case, rather than a statute that was passed by Congress. Contrary to the Loper standard, the Department of Justice here again was not attempting to interpret a federal statute. As a public policy matter, agencies do have subject matter expertise, are in a much better position to understand their own regulations. Agencies no doubt have great decision-making powers. It is essential that their regulations that they are enforcing are interpreted properly. Their decisions can affect many people, and thus the agency here is in the best position to interpret those regulations to ensure that Title II of the ADA is carried out properly. The Loper standard holds that courts must independently interpret statutes using statutory construction tools rather than automatically owing deference to the agency's interpretations. However, respondents would like to address that the ORA standard is not allowing for automatic deference here. The standard is to be used only when the regulation is ambiguous, and it may not, again, there are two safeguards in place to extend to those, that it does not extend to those that are plainly erroneous and inconsistent. Additionally, my opposing counsel has mentioned the Kisser versus Wilkie standard that did limit the ORA standard. However, even under this, the guidance document should still be owed deference under this. The Kisser versus Wilkie standard addresses that regulatory interpretation must be by the agency's authority rather than an ad hoc statement. It must implicate its substantive expertise, and it must reflect its fair and considered judgment. Here, Congress has specifically empowered the Attorney General to enact these regulations. They have designated the Department of Justice and its staff as the primary source of interpretation and application of Title II. And the regulation here is not attempting to create a justification nor to defend past actions. There is no evidence to reason that it does not reflect the agency's fair and considered judgment here. The ORA standard is controlling and allows this court to owe deference to the Department of Justice's interpretation of their own ambiguous regulation.
Just because Congress allows the Attorney General's office to adopt broad overarching regulations and gives them authority to enforce those regulations, can we make that jump that they were also intending to allow the Attorney General to step in on behalf of individual at-risk individuals?
Your Honor, respondents would argue, I believe that would be in the what my co-counsel will be addressing. We would argue, yes, that they should be allowed to intervene here to protect these individuals. And I assure you, my co-counsel will go into much more depth with that as well. Due to the ambiguity of the integration mandate, the guidance documents published by the Department of Justice interpreting this mandate should be owed deference. If I could provide a brief historical context to you to show you how the how the guidance documents came to be and why it is so important that we owe it deference. Congress has provided the basic framework that a public entity may not discriminate against any qualified individuals based on disability or deny them the benefits of services, programs, or activities of a public entity. Congress has found that society has historically isolated and segregated those with disabilities, and this continues to be a serious and pervasive issue. Based on these findings, Congress empowered the Attorney General to enact regulations implementing the provisions outlined in Title II and to enforce those. In response to this, the Attorney General set forth a regulation now known as the Integration Mandate, asserting that a public entity must provide services, programs, and activities in the most integrated setting appropriate to the needs of the individual with disabilities. The Olmstead decision decided by this court in 1999 held that a person has been discriminated against when he is unjustifiably institutionalized and denied the benefits of the most integrated setting available in the community. The Department of Justice has stepped in here to provide the much needed interpretation of an ambiguous regulation. And the document specifically stating that this holding in Title II extends to those at risk of future institutionalization and segregation. Davis versus Shaw provides the standard that asserts here that when there is a creation of the Department of Justice's own regulation, their interpretation of that provision is controlling. To provide you brief context of past cases and when this court has allowed for deference and dispositivity to guidance documents and interpretation of agencies. The Ford Motor Credit Company versus Milholland allowed Congress to delegate authority to the Federal Reserve Board to interpret the Complex Truth in Lending Act. The board here enacted Regulation Z to fill the statutory and regulatory gaps. This court held that deference was appropriate and that the board's interpretation of the act and regulation should be dispositive. Respondents would also like to address the language in the guidance document, and most notably the phrases in accordance with applicable laws and the statement that the document is not legally enforceable beyond what is required by the terms of applicable statutes, regulations, or binding judicial precedent. In the Orr versus Robbins case, the phrase subject to was enough to meet the burden of deferential standard. Subject to meaning dependent on or conditional upon the regulation. Respondents argue here that the phrase in accordance with applicable law simply meaning to be governed or limited by law, and the phrase that document is not enforceable beyond what is required by the terms of the applicable regulations, and a context meaning is subordinate to a regulation or statute. Although these phrases are not the same in definition or the same in phrase wording, respondents argue here that it is essentially, these phrases are meaning that it is dependent or conditional upon the regulation here. Respondents argue that this should be enough to meet the burden of deferential standard. To conclude, we must ensure that the dignity of those with mental disabilities by providing them with the appropriate services in the most integrated setting. Because the integration mandate is ambiguous, the Department of Justice's guidance documents must be owed deference to interpret the integration mandate properly, because the Orr standard is controlling here rather than the local standard. Respondents request that this court must affirm the Court of Appeals decision because Title II of the ADA does in fact extend to those at risk of future institutionalization. This court must do everything it can to ensure that these individuals are properly taken care of. Thank you.
Chief Justice, Your Honors, may it please the court. I'm Danielle Watkins, also representing the respondents, and I will be addressing the second issue that the United States qualifies as an interested non-party intervener under Federal Rule of Civil Procedure 24A2 when a state violates Title II of the Americans with Disabilities Act. This case is about 3 patients facing discrimination by state hospitals because of their mental health disability treatment needs. The state of Franklin violated Title II of the Americans with Disabilities Act by being one of the largest states with a spread out population and not providing the proper treatment that was recommended by the respondents' treating physicians. Justice Sholar, you asked a question about the standard of review. Petitioner said that it was de novo. However, there is history of a circuit split here. And so my first point should be reviewed de novo and the second for abuse of discretion, because it is the way that the facts are applied to the requirements of 24A2. This court should affirm the 12th Circuit Court of Appeals opinion and review. My first point de novo and my second for abuse of discretion. First, Congress authorizes the United States to bring lawsuits against agencies violating Title II of the ADA as laid down in United States versus Florida and the language of 42 USC Section 12101B3. Second, the United States was able to intervene as a matter of right under 24A2 because it had a subject matter interest in the application already filed. Congress uses cross references in language throughout other statutes to show their intention for the authority of the Attorney General to have enforcement under the ADA. Language in Section 12101B3, the very beginning of the ADA, specifically states that the purpose of this act is to ensure that the federal government plays a central role in enforcing the standards established in this act on behalf of individuals with disabilities.
Before you get there, counsel,
Yes, Your Honor.
if we were to disagree with you on issue 1 and follow the lower deference, wouldn't this make your argument moot? Does your case go away?
No, Your Honor. We would still have the intervention and the cross language to be interpreted here. The United States versus Florida is a case out of the 11th Circuit, which states that Congress gives the United States right to enforce Title II through a series of cross references. The enforcement mechanism of Title II of the ADA is ultimately Title VI of the Civil Rights Act of 1964. It was the inclusion of the Civil Rights Act that gave the Department of Justice Civil Rights Division the expansion of their authority into prohibiting discrimination in public facilities. By definition, the petitioners are these public facilities, and because their state government, they are a state government department and agency with special purpose in the area, they are required under the act to make sure that people receive treatment. If you look at the legislative history that you referred to, Justice Sholar, it is actually the language in the Senate Committee of Labor and Human Resources report and House Committee on Education and Labor report that note that Title II's enforcement provisions specify that the remedies, procedures, and rights are those available in Section 505 of the Rehabilitation Act. That report also echoes that Section 505 refers to Section 405 of the Act, and 405A of the Act refers to the enforcement procedures, specifically describing the remedies, procedures, and rights set forth in Title VI of the Civil Rights Act, which is also laid out in Section 12133 enforcement that petitioners referred to earlier. It specifically left out the section that says the rights set forth in this section are 794A of Title 29, which specifically refers to the Civil Rights Act. Petitioners would like you to believe that because Congress does not specifically address the power of the Attorney General in language of Title II, but it does in Titles 1 and 3, that Congress intentionally left out the Attorney General. And that is simply just not the case here.
It's a qualified individual.
Well, Your Honor, they are technically in themselves not a qualified individual, but it is the fact that they are here to represent the other qualified individuals that may not have brought a suit yet in this case, but could still be at risk, considering the fact that they live in the state of Franklin and do not have access to proper treatment. By addressing the federal government in the opening provisions of the ADA, Congress did not feel the need to continuously refer to the role that the Attorney General shall have throughout the Act. It is a different section in Title II. Title I refers to employment discrimination, and Title II refers to public entities that we have here today, and Title III specifically refers to private entities. So if Congress did not want the Attorney General to have authority to take care of public entities, why would they refer to them through cross language in multiple acts, such as the Rehabilitation Act and the Civil Rights Act?
But as Justice Hoffman points out in his dissent, page 32 of the record, if that's the test, the Attorney General's office can jump in almost any case, anytime they've promulgated regulation, they can jump into any case. That's going to make it a pretty broad test to apply, other than the specific situation we face here.
Sorry, Justice Vaughan, I'm not exactly sure if I'm understanding your question. Would you
You
repeat?
say because there are regulations and the Congress said the AG can enforce those, they can jump into this case. But Justice Hoffman points out page 32 that that's the case of any case. You won't have any longer individualized review of what the Attorney General did if they can jump in anytime they promulgated a regulation. Is that the proper test then? That because they promulgated a regulation, they can jump in to defend or prosecute this case?
Yes, Your Honor, that would be under the enforcement of the Title II, where it specifies the procedures, rights, and the fact that the Attorney General does have the ability to issue those regulations. They should be able to make sure that people are receiving that proper care. Moving into the fact that the United States does have an interest in the action because the language of Title II of the ADA states the remedies, procedures, and rights set forth in Section 505 of the Rehabilitation Act, as I had referenced. There used to be 3 facilities in Franklin. After some legislative budget issues, they did close 2 of those facilities. The inpatient treatment at the only facility left in Platinum Hills was all that patients had. However, they did close that one as well. But if you look at the record at page 16, petitioners received a budget increase of 5%, which nowhere does it show that that budget increase went to provide any additional care or reopen even the treatment facility that was at Platinum Hills. These facts show that the interest that the United States has in the subject matter of this litigation. Later in the ADA, Section 12188B1B states that if the Attorney General has reasonable cause to believe that any person or title of persons has been discriminated against under this title, such discrimination raises an issue of general importance, the Attorney General may commence a civil action in any appropriate state district court. This litigation raises a question of general public importance because allowing the Attorney General to bring this litigation would not just be to help out these 3 specific respondents, it would be for the rest of the citizens in Franklin.
How do you respond to the argument opposing counsel made that because the United States was allowed to intervene, the schedule got delayed, the cost ballooned? I think he quoted discovery ballooned to 31 depositions and 48 subpoenas. The cost of time, this case below took over 26 months, and this amount spent to the United States involvement caused it to spend more than $273,000 in additional attorney's fees. That seems like quite an increase by allowing the United States in over just the 3 individual claims.
Yes, Your Honor. I do understand petitioner's point here, trying to address the fact that there was prejudice, as they say. However, it is the respondent's position that if it were not for the United States intervention here, they probably would have been bullied by a larger state department trying to get a quick and easy plea to settle this case. The United States being involved can address this issue and make it so that this will not come forward again in court, and that though there's a lot of inflation of the budget, it is something that would prohibit this from coming forward to you again.
Doesn't that argument simply assume that United States lawyers are better?
Not necessarily, Your Honor, just that in a sense, they're looking out for more than just the 3 respondents here. The inclusion of the United States in this case actually neither weakens nor strengthens the case for the respondents of Sarah, Eliza, and Malik. They will still have a case as qualifying individuals that have faced discrimination and are at risk of being institutionalized again in the future. Based on Congress's integrated language throughout the statutes of Title II of the Americans with Disabilities Act, Section 505 of the Rehabilitation Act, and Title VI of the Civil Rights Act, it gives the United States authority to bring actions against agencies that have discriminated against qualified citizens such as the respondents and the other citizens of Franklin. This gives them a subject matter interest in the litigation meeting the requirements of Federal Rule of Civil Procedure 24A2. Respondents respectfully ask this court to affirm the opinion of the 12th Circuit Court of Appeals. Thank you.
Yes, Your Honor. May it please the court, I have two quick points on rebuttal. Your Honors, the respondent's case is a slippery slope. Not only is it factually different from Olmstead, but the respondents in this matter are not even institutionalized at the moment. As well as the central role does not include individual suits. As written, the United States Attorney General actually represents the public as a whole, and there's no mention of individuals. Going into the first point, Your Honor, that Olmstead is factually different from this case in that the individuals that were seeking remedy in that case were actually institutionalized, and they brought their claim whenever they were in the institution. While it is not the primary purpose of this that the petitioners want to deny care for those that are in need, it's just that these particular respondents are not those to bring this claim, as they are currently integrated into the best setting as they are in society. As well as it was posed earlier that what is the standard to determine at risk? And that will lead with this question: what standards will physicians use to determine this? Who will oversee it? Will this cause taxpayers even more money? These questions have to be asked in order to determine how will substantial at risk or at risk be determined. And Your Honors, it is because of these reasons that the petitioners ask that this court reverses the 12th Circuit's decision and does not allow the at-risk claim to be recognized, nor allow the United States to intervene. Thank you.
Well, take this matter under advisement. Make sure we win the reports. Thank you very much.
Thank you very much.